Hello, Mr. Koble back again. Newly shaved, fresh Mr. Koble looking back again. And we're going to talk about the Bill of Rights today and what it is, why it happened, and most importantly, what they are. What are your rights? Do you have rights? You don't. No one has rights. All right, but the Bill of Rights is basically the first 10 amendments to the Constitution that protect basic liberties. So if you actually look at the Constitution, you go through the 7 articles, yada, yada, yada. After that, you have amendments. And amendments is basically a fancy way of saying, here's extra stuff we are adding on or changing after the Constitution's been created. So like, yeah, there's some extra stuff. It is very hard today to get an amendment passed, so it has to be a very popular thing now. But at the time, these were the 10 they decided when they're making the making the Constitution. So, big question: why do we have them? During this time, a lot of anti-federalists, which is these people, because they don't like government. They're like, "Ew, government, get away! You're ugly and gross. We don't like you." So, kind of like. Okay, I was gonna make a joke there, but I won't. Y'all can figure it out. Anyway, these people were worried that the Constitution made the made the federal government too strong. Jefferson does not like Hamilton in the Federalists. Well, Jefferson does not like Hamilton in the federal government being too strong. They said we fought an entire war because British governments was too strong and too tyrannical. Why are we trying to make the feds strong again? So, considering that most states needed to ratify the Constitution, which means approve it, they needed 9 states to sign off on this. A lot of states and a lot of people didn't feel comfortable with the Constitution at the time. It was very controversial. One of the big things was we need to make sure our rights are guaranteed. So a lot of the people that were fighting for the Constitution said, fine, we'll add a Bill of Rights protecting American citizens and their freedoms. And not southern states, a lot of states saw that were previously hesitant and were like, cool, we're in. Yeah, go Bill of Rights. God, I look 15. Anyway, so that is why they were added in the first place to the Constitution. So what are they? And, this is where your note taking is going to come in handy. First Amendment. It's made up of 4 things because that makes sense. But anyway, First Amendment, there's a whole bunch. So get your pencil ready. The first one is freedom of speech. And I'll go over exactly what this means in a second. The second one is freedom of religion. The third one is freedom of press, which I guess is an extension of speech. And the fourth one is freedom of assembly to protest your government. So, that's kind of the fifth one. But basically, your big 4 are speech, press, religion, assembly. So Congress or any state, because all states have to abide by the Constitution, Congress shall make no law respecting an establishment of religion, so you can't make a national religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peacefully to assemble and to petition the government for a redress of grievances. So we are filming this in the cursed year of 2020. During the summer part of the year, we had a lot of protests. This is protected by the First Amendment in the Constitution, the right to peacefully assemble. So this is kind of the 4 big parts of the First Amendment. Now, does this mean you can run around saying a bunch of stupid things? No, you can't, because here's what it actually protects. Hang on, I'm going to make this. I'm going to edit this. I'm going to make this, do this instead, and not do that. And there goes my punchline. Whatever, it's 2020, and everything's a failure. Okay, did I do it? I think I did it. All right, let's try it again. Okay, no, not that. Man, I actually like not recording these a second time. I like seeing all my mistakes. All right. So what does the First Amendment actually protect? It protects freedom of religion. So government cannot fine or jail you based on your religion upon reasonable ground. And if you did have a religion that made you do things that were very unreasonable, it would not be protected. So, for example, if I don't know, if there was some religion that told me how to eat babies or whatever, and I ate a baby, I could not go to the Supreme Court and say, well, Supreme Court, on your honorable whatever's, clearly this is a violation of my freedom of religion because my religion clearly tells me I have to eat babies. So therefore, that is my First Amendment right. You cannot do that. That is unreasonable. So for kind of all of these amendments, there is an element of reasonability to it. And that's why we have the Supreme Court, to decide what is reasonable and what is not reasonable. Another part, government cannot prioritize one religion over another. So you guys have Christmas break built into, you have all your holidays built into your schedule. So all of you, everyone in America gets time off around Easter, gets time off around Christmas, gets time off around the big Christian holidays. But for me, if I want to take a Jewish holiday off because I'm Jewish, then I would have to get a sub for that day. If they docked me a sick day or a personal day or whatever it is for celebrating a religious holiday that is valid and is reasonable, then I could sue saying, hey, this is discriminating against my freedom of religion. And every single state has a law that talks about not anti-discrimination against different religions. So you cannot do that. So this is kind of the idea behind separation of church and state. You do not want the government also running religious affairs, because that's what happened in the medieval ages. And I had all of you as 7th graders, and you know that didn't turn out very well. It's generally not a good idea to have your head of government also be your head of religion, because there's a lot of conflicting interests there. So overall, businesses, employees, employers, schools cannot discriminate based on religion. This one's actually not directly in the Constitution, but it is a civil rights law that got brought up because it just decided it was a good idea to include it in all the other anti-discrimination practices. So now it is. But yeah, once again, like all constitutional issues, there is gray area. On the left, I have a story I'm about to play about a Muslim woman who mentioned that she would need prayer breaks throughout the day, and the business would not accommodate her and therefore did not hire her. And she's saying that is a violation of her freedom of speech, and I will let her speak for herself.
He said, religion, we don't want that here. And then he pointed to my headscarf. Everything was going well. It lasted about 15-20 minutes. And then she explained to me the roles, the hours, how to progress within the company. And she said that there would be a 2-hour lunch break, to which I said, that's kind of a long lunch break, but is it possible for me to take a shorter lunch break and instead take 5 minutes throughout the day to pray? And I asked her for 2 5-minute prayer breaks, which would amount to 10 minutes total, because I pray 5 times a day in accordance with my sincerely held religious beliefs. And she promptly ended the interview. She said, that's not going to work. We have fixed hours here. As we were walking back to the office, I thought, why don't I talk to somebody else in charge? Maybe they'll be able to help me out. So we were at the front desk in the office, and the CEO, Ramses Gavilando, he was at the front desk. The assistant manager, she handed him my resume, and she said the hours don't work for her. And it was kind of like he already started looking over my paper and marking stuff up. So I quickly asked him that, do you think you can accommodate my 5-minute prayer breaks? And instead, I'm willing to take a shorter lunch break. And he said, what? And I repeated myself very calmly. I thought he just simply didn't understand. But the way he was asking me, the way he said what was also very condescending. And I said, well, because of my religion, I have to pray 5 times a day. And 2 of those prayers are going to happen within the hours of the work that you guys told me, because it was from 11 a.m. to 8 p.m., I believe. And I would have at least 2 to 3 prayers that I would have to pray. So I asked him, can you guys accommodate me? And I'm willing to take a shorter lunch break. And he said, religion, we don't want that here. And then he pointed to my headscarf, and he was making all sorts of like hand movements and becoming very loud. And I was still like calm. I was just trying to explain to him the situation. And he was just like, religion, we don't want that here. We don't want these religious shenanigans here. I was shocked, and there were other people around me. There were other employees. There were other interviewees there, and I just felt very humiliated. He made some X's on my paper, on my resume, and that was it. I just kind of quietly left the office. I didn't want to create a scene or anything, but I was pretty hurt and pretty embarrassed.
Title VII of the Civil Rights Act prohibits employers from discriminating against individuals on the basis of religion and other protected classes. And moreover, employers are required to accommodate applicants and employees with regards to their sincerely held religious beliefs, as long as that does not pose an undue burden on their office operations. 2 5-minute prayer breaks don't pose any type of burden on an employer. Those breaks can be taken in a private area without disturbing anyone. They can be taken on the side. They're predetermined, and so she would know at what time she was required to take those breaks. Fast Track has absolutely no basis for what they did, and they were very clear in the fact that they refused to hire Shaheen because she requested those breaks.
Pause this recording. So I know it's now this, and now this can be sketchy sometimes, but that is a really good example of a case where religious discrimination would come up, and would probably, if that lawsuit kept going, would probably be decided at some state level court. All right, exit, cool. So my question for all of you is, given what you've learned so far about gray area being in constitutional issues, is this: would Mr. Koble be able to be fired, fined, or jailed for practicing Marvinism and setting cabbages on fire in public? Discuss with your group. Yes or no? Would it be constitutional, I should say? Pause it, whatever you need. About 5 seconds. All right. So the answer to that question, since Marvinism is not exactly I don't say it's not a real religion, because your grades, Marvin may destroy your grades, but it would be in this gray area, and it would be decided under this reasonable clause, right? I cannot make up a religion, do whatever I want, and then decide that anything violating that made up religion is I can do it because of freedom of religion. If not, everything's liable to gray area by the Supreme Court and by judges. Okay. And a lot of the kinds of, freedom of speech, freedom of religion, freedom of press, freedom of assembly operate under that same guise. There's always some kind of gray area, or there's always some realm of, is it reasonable or not, that operates. Like, what is the intent of the amendment versus what is it being used for? Which we're gonna come to that later, because we're gonna do some court cases together. But the Second Amendment is the right to bear arms. And no, this is not a pair of bear arms like grizzly bears. This means the right to own and carry and use guns. So they made this in the Second Amendment. because they had just fought a war against the British government, and they wanted to make sure that if this kind of thing ever happened again, where you had a government overusing its kind of abusing its power, that the people were allowed to fight back. That was the intent behind it. So Second Amendment is your guns. There's been a lot. I student taught after the Parkland shooting happened, and there was a lot of debate about the Second Amendment. Your opinions on it will likely differ depending on how you've grown up. If you've grown up with guns, not grown up with guns, that kind of thing. But it's a very interesting one. It's not going anywhere. Okay, Third Amendment. This one's never brought up. This is you cannot force citizens to house soldiers. This is a relic of the past. During the Revolutionary War, American families were forced to house British soldiers in Boston and other parts like New York. So British soldiers would land in the city. They drive out the I want to say rebels, but they drive out the Continental Army, the Patriot forces, and then they would live in the homes of American families that were forced to feed and house them. This was, as they put it back then, not chill. So they put this in the Constitution. I don't think it's ever been, maybe like there's 2 court cases in 200 years about this. I don't know. Fourth one, this one comes up a lot. Police cannot search your personal belongings, your car or your house, without a warrant or probable cause. And this one you need to know. So let's say, say I get pulled over and they say, Mr. Koble, we'd like to search your vehicle. And I could say, officer, do you have a warrant? And if they say no, say, well, do you have probable cause? And if that depends on what they decide is probable cause. If I am driving erratically and swerving over the road and there's a half bottle of drank vodka in the back seat, then yes, that is probable cause to search my vehicle. There's been a lot of debate and a lot of controversy over what constitutes as probable cause. And maybe some instances, there's officers that are stretching the truth, or some examples of, things that really aren't a big deal, but are determined as probable cause. So this is a huge one. This also applies to students. So what this means is if I say, I'm going to pick a random name of a kid that I don't have, that I've never had before, Hector Martinez. If I say, no, I'm sorry, that's mean. If I say, put your backpack, give me your backpack, I need to search it. You can say, well, what is your probable cause? And if I say, I just feel like it, then that would be unconstitutional. But if I was like, yeah, you're busted on cams doing some not, it's gonna be filmed. Okay, what's happened in past schools is there's been rumors flown around and camera evidence to back up kids selling drugs at school. So that would be an example of probable cause to search that kid's backpack. So that would be necessary. That's like kind of what probable cause means. Fifth Amendment, double jeopardy. This one doesn't come up that often. So what this says is you cannot be tried twice for the same crime. That's all double jeopardy means. So let's say you get tried for murder and you get called not guilty, and the prosecutor and judge are just like, nah, I don't like you. We're just going to try you again until you're guilty. Like, that'd be pretty messed up. Now, you can appeal your case. So let's say, so this happened in the 1900s a bunch, where you would have Black defendants, so Black men on trial, and they would be accused of something, and the jury would be an all-white jury in the middle of nowhere, Mississippi, where lynchings happened all the time, and they would all say guilty even if there's like no evidence. They could appeal that case, say they were not entitled to a jury of their peers. This was a mistrial, and they could get it appealed and done again. but you cannot, like, judges and prosecutors especially cannot like try someone again because they didn't like the ruling. You can appeal your case and say you didn't get a fair trial, but you cannot be tried again by the government. That's just like, no, we messed up. No, it's not chill. That's why OJ can't get put on trial again for that crime that he committed in 85 or 94 or whenever it was. Fifth Amendment also says you have a right to a trial. You have a right to a fair trial. You have a right to a fair trial of a jury of your peers. So right to a trial, a fair trial to a jury of your peers. So whenever you get put on trial for a criminal case, there has to be jurors there that will vote on your sentence. The last one's wonky, and we're not going to really cover it that much, but it's called eminent domain. Basically, the government can buy your land, take your land for money. Usually it doesn't happen that often. It's very unpopular. An instance where this would happen is in San Diego. San Diego, they are trying to build another trolley line that goes to UCSD from Old Town. And a problem that they were running into for a little bit is that it was cutting into land that some businesses owned. So the city of San Diego could, buy out that land, take that land, give them money for whatever the land was valued at, and continue on their merry way. This actually happened in my hometown of Poway, I think. They're trying to build a second lane on the Spola Road. All right, so that is the Fifth Amendment. Sixth Amendment. You have a right to a speedy and quick trial. If you are waiting 30 years for your shoplifting case to go to trial and you're waiting in jail, that is, as they called back then, not chill. So this means that your trial has to be relatively quick and speedy and get there kind of as quick as it can. If you obviously have a high profile case like OJ Simpson or recently Kyle Rittenhouse, like, yes, it's going to take you more time for that state to find you a fair jury and to make sure that you have a fair trial. But that is the Sixth Amendment. Seventh Amendment, keep going with trials. Trial by jury in a civil court as well. This one doesn't come up that much, but you can. It's basically saying, hey, yes, if you need to have a jury for murder, but you can also have a jury for your divorce settlement as well. When I did jury duty, I can't give any details, but I got placed on this one at first, and I was like, oh, he did what? Oh, girlfriend's gonna get paid. Yeah, it was pretty fun. She's malicious. Eighth Amendment, bail and there's two parts to this. One's bail. This is paying your way out of jail. This is actually on the bail reform was on the election ballot. It was one of the propositions in California. It didn't pass. But basically, you commit a crime. That means you have to wait in jail until your trial. This is a problem if you have to work and have a life outside of jail. So basically, bail lets you pay your way out and you come back to your court date on a later day. Obviously, if you are a serial killer, they will not give you bail. So once again, there's that reasonableness to it. Another one, excessive fines. You cannot be fined excessively. I cannot be fined $70,000 for a speeding ticket. That would be excessive. Last one, the one it's most known for, is cruel and unusual punishment. And the most commonly, so you cannot be tortured for robbing a bank. That'd be cruel and unusual punishment. But one of the big debates on this is death penalty. Is the death penalty a violation of the Eighth Amendment, which is cruel and unusual punishment? That is something that is argued quite a bit, and it's still up for discussion. It's a very interesting discussion. Then the rest two are kind of weird. Ninth Amendment, it's like it says not all rights are explicitly included in the Constitution. Even if some of them aren't included, people still have them. Ninth Amendment's like, they're making this in 1789, and we're like, oh my God, we're tired. We want to get out of here. Just write the last two amendments as anything we forgot, people still have them or whatever. That's basically the Ninth and 10th Amendment. So not all rights are explicitly included in the Constitution because they couldn't think of them. If some of them aren't here, people still have them. So the right to privacy is like the biggest one I could think of, which was decided in 1973 during Roe versus Wade. The 10th Amendment, we are going to talk about. The 9th Amendment, people don't really care that much. 10th Amendment is going to be important, though. And the 10th Amendment says that any power not explicitly given to the federal government are given to the states. So when you had your kid-friendly Constitution, you were reading all the stuff that Congress is allowed to do, or the president is allowed to do. There's a lot of stuff that realistically is missing, right? Like, it never included pandemic reform or pandemic rules. There's all kinds of stuff that are not explicitly put in the Constitution, because how are they supposed to know what's going to happen? So the 10th Amendment basically said anything that we explicitly did, which means clearly and in writing, anything we did not clearly in writing give to the federal government, it's the state's responsibility to figure it out. So this basically gives a lot of power to the states. So during the COVID pandemic response, a lot of the quarantine rules varied state to state because the federal government said, like, we're not doing it, states figure it out. So this basically gives states extra power to govern themselves, which the states like. Look how happy they are. Look how happy, California is because we're the best. And look how happy, Washington is because West Coast, best coast. Look how happy Virginia is because they, I don't know, they have clams, I guess. And then Florida should never be happy because they're Florida. All right. But if you're like, Mr. Koble, wait a second. I remember during the Constitution, you made a really big deal about this thing called the Elastic Clause. So the Elastic Clause in the Constitution said that Congress, who writes laws and are part of the federal government, can do anything deemed necessary and proper to carry out its responsibilities, meaning Congress can do whatever it wants to do its job. So necessary and proper, right? So basically, congressmen use this to do whatever they wanted. But you're like, wait a second, that goes against the 10th Amendment because this says that states should have all the power that isn't given to Congress. But this says that Congress can do anything it wants. So what happens? Yeah, who knows? Supreme Court figured it out. We'll have to figure it out. And that's basically where we've been for 250 years. So once again, 10th Amendment, states are happy. Elastic Clause, states are mad because Congress, feds have a lot of power. I don't know why I put that. I did this. I made this last year. I don't know why I put that. They're mad, I guess. I don't know. Anyway, here's your job. You are America's next top model citizen, meaning that you will have to hear a number of Supreme Court cases. After I give you each court case, you're going to pause this video and you're going to decide how this court case should be ruled. Is it constitutional or is it not constitutional? So you and your group are going to decide. So here's your first one. Ingraham, and I erased a lot of the ones I did last year. Ingraham versus Wright, 1997. Scenario: James Ingraham, a 14-year-old 8th grader in Miami, was taken to the principal's office after a teacher accused him of being rowdy in the school auditorium. The principal decided to give him 5 swats with a paddle, but James said that he hadn't done anything wrong and refused to be punished. He was subsequently held down while the principal gave him 20 swats. While corporal punishment was allowed in the school district, I want to say this is like Mississippi, James had bruises that kept him out of school for 10 days and he had to seek medical attention. James and his mother sued the principal and other school officials, claiming the paddling violated 8th Amendment protections against cruel and unusual punishments. So, put on your Supreme Court hat because you and your group are going to decide what the ruling on this is. Is this constitutional or is this not constitutional? You decide. So pause it. We'll come back to it in a second. Oh, cool. So does the Eighth Amendment protect students from corporal punishment? Why or why not? They ruled. Here's the result. This was constitutional. States, school officials were allowed to do this according to the Constitution. Their in-depth thing was the Supreme Court ruled against James, and they said that reasonable physical discipline at school does not violate the Constitution. They said the Eighth Amendment was designed to protect convicted criminals from excessive punishment at the hands of the government, not school children who misbehave. The court basically left the question of whether to allow corporal punishments up to the states and local school districts, which usually set most education policies. So they kicked it back to the states and they said states figure it out. But they said, yeah, that it does not violate the Constitution. Fun stuff. Okay, next one. New Jersey versus TLO. TLO is the name of a student. They could not, I don't think they could name the student back then. I don't know. Whatever. Scenario, a high school student is caught smoking cigarettes in a public school's bathroom. The student is taken to a vice principal's office and questioned. She denies she was smoking. The vice principal searches her purse and finds cigarettes and rolling papers, which are associated with marijuana use. The principal then searches the purse more thoroughly, finding marijuana and evidence that the student was stealing marijuana. School authorities call the police and the state brings charges against the student. So here's the question. Do public school students have the right to be protected against having their belongings searched by a principal? Why or why not? So does this violate the Fourth Amendment, which if we go back, is all about search and seizure. So can your belongings be searched without a warrant or probable cause? That is the essential question. So pause it and we'll give you about 6 seconds to think of your ruling. 3, 2, 1. All right. This search was constitutional. The Supreme Court said that the search was reasonable given the scenario. So they said that in this case, the principal searching her purse or whatever was reasonable because of the circumstances of she was caught smoking in the bathroom. She denied that she was smoking. That was all, according to the Supreme Court, reasonable probable cause. So that one was, student lost that one. When you guys get into 12th grade, you'll learn all about student rights and what rights students do have at school. Not many. No, you do have a bunch, I should say. All right, last one, Schenck versus the United States. This is in 1919. I didn't put a date on it. Oh, look at that, I did. Go me, go past me. Year is 1919, and the US has just entered World War I. Charles Schenck is arrested for handing out anti-war propaganda, which violates a law from 1917. Is Schenck's right to free speech being violated? Which amendment? Discuss with your group. So, is this constitutional? Give you about 5 seconds. 2. Supreme Court ruled on March 3rd that the freedom of speech protection afforded in the United States in the First Amendment could be restricted if the words spoken or printed were a clear and present danger to society. So according to the Supreme Court, this anti-war propaganda presented a clear and present danger to society. For example, if I went into a crowded movie theater and yelled fire, and that caused 2 people to die because they were trampled to death, I would not be protected by freedom of speech, because me going into a crowded movie theater and yelling fire when there is not actually a fire presents a clear and present danger to society. Therefore, it would not be protected. So once again, there's this element of reasonableness in all of these amendments. Okay, so that's all the ones that I've presented. But at this time, last week, there was a court case, and you're going to learn, we're going to go over this in class, and this is going to be your next assignment. But there was a court case where a church and multiple religious establishments in New York said that they were suing the governor because the governor was putting limits on in-person social gatherings, such as church services. So churches sued, and it went to the Supreme Court. And the argument was that the governor of New York is unfairly targeting religious institutions for these social population in-person gathering bans because of the COVID-19 pandemic. So your assignment, and I'll explain this in a minute, probably on Friday, is going to be, in your opinion, is this constitutional or is this unconstitutional? And you will have to defend that ruling with your explanation about why this is or is not constitutional. So that is going to be your assignment. Hopefully you enjoyed this. This is Mr. Koble. Peace out, squad.